So we got this case here with the Fulton County, Georgia District Attorney Fonnie Willis, and situation with her and her paramour or her boyfriend, Nathan Wade, who is in the middle of a messy divorce. And we're just going to review this testimony right here on the stand right now is uh, a former partner of Nathan Wade and a business partner also. And he was also his divorce lawyer in this proceeding that's taking place between him and his wife Jocelyn.
Understood. Yes. And it's your testimony that the information that you imparted to Miss Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge, specific.
Now, this guy that's on the stand has the goods. Again, that was Nathan Wade's lawyer. Um, he was the one that talked to Ms. Merchant, one of those 19 defendants in that RICO case. He contacted her and he gave her the goods about the relationship between Fonnie and Nathan Wade. And the thing was, he was pissed off because he was kicked out of the firm, on some allegations of sexual misconduct.
Knowledge comes from Mr. Wade, which we've already established.
Well, no, the question, he didn't get into anything. He just said, are these two text messages about privileged communications? We haven't actually, I don't see an issue there.
Yes. And is it your testimony that the knowledge that you have, which you imparted in these two text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
And I think that
That's what you're going to do. Sure.
so I'll sustain that on privilege.
And I'm going to introduce for the record when we finish these two text messages so that Your Honor has those back there so that you can,
Sure. What would they be marked as?
what do you have? I'm gonna go ahead. Once I put a staple in it, I think it'll be Defense Exhibit 26.
All right, so this is marked and made part of the record as Defense Exhibit 26, but not necessarily for its.
This is not admitted
Evidentiary value.
26. This is for purposes of the court conducting the in-camera review. And put a staple in it. Here's make sure that you see.
All right, I'm gonna say that. What else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in an email.
Actually, do we know? You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but
Okay, I'm going to get it for you because
Okay.
I don't want there to be any assumption. Let me show you. This is.
Jared.
I'm going to show you if I might approach. I made reference to an email that Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:25 a.m.
Yeah, I see it, the email, yes.
That's the email that you received.
While he's coming out, Ms. Merchant, for planning purposes, based on how Mr. Bradley's testimony was presented, do you anticipate calling any further witnesses?
I had a copy of the I think you got it.
Right. We'll handle that with housekeeping at the
Yes,
end.
okay.
Okay. Ms. Cross.
Thank you. Mr. Bradley, have you still got the exhibits 23, 24, 25 there in front of you?
I do.
And 23, that's one of the contracts for that was your personal LLC or PC, your personal legal entity, right? For the
That is correct.
Attorney's office? Yes?
Yes, that's correct.
And I understood your testimony to be that any income that came into the partnership, when I say partnership, let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity. But y'all had a partnership agreement, right?
Yes, but we didn't have that the entire time.
There was
Yes.
a period of time that we've been talking, or that we had talked about in 2022 prior to leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all bought a building together.
Yes, correct.
And it made things simpler, or for whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts there. And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes,
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
that is correct.
2020, more than one occasion.
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had security detail before she became DA. So, I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think. But I do remember twice her coming to our office, correct?
And she had a security team both of those times.
There was yes, she has a security team with her.
And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well, let me ask-
However,
I'm sorry.
I don't know her security team now. I don't know her security team now.
You remember telling me that it changed at some point, her security team.
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that, no, but
Do you recall talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah, objection based on, we don't know. This is either based on privileged information or it's hearsay. Neither one.
It's neither. I asked if you recall.
You need to clarify it. If you're actually going to if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. Sustained.
Are you aware of other people that you believe would have known about when their relationship began? I object to the relevance of that. Again, the witness is testifying. He has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So maybe you can ask more overarching questions. And if you have anything else you think that's relevant, then you can get to those as well.
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you and you read it, reviewed it, and emailed me back that everything in it was accurate. To your knowledge.
You emailed me, and
Objection.
Okay. All right. So there are things contained within that, Ms. Merchant, which he has now said fell within the privilege and they did not have the ability to waive. So I think that's where we have to leave it there.
And I believe I still have to ask the questions, and then if he wants to assert the privilege.
Well, I think we pretty much already established the privilege and the objection has been made, and I think it's a valid one at this point based on the record. So the answer was you did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see. It was, let's see, I think it was January 5th.
Judge, I just want to, on behalf of Mr. Wade, just to review the motion again. We still don't.
To which question?
To the current question, we still don't know the source of this information, whether it was privileged or how he obtained it.
I'm wondering now if there's a timeliness issue on your objection since he already, well, he said he doesn't recall. So
Right,
there's,
he just gave the date. He didn't.
Sure.
Sorry.
well, his question or his answer was he doesn't recall and his memory has not been refreshed. So I think it's time for the next question.
May I persuade you?
Okay.
Can I see what you're question? What is it? Is this a complete text change?
Yeah, it's a complete question. While they're looking at that, can I just ask you, did you delete any text messages?
I have several messages in the phone with you. I've never deleted. I mean, there are messages.
And I don't have anyone downloaded.
Mr. Seda.
The court is a trier of fact. You're going to be able to determine whether it's something that has come in if you choose to. It's hearsay, whether it's admissible, whether it's relevant, whether it's impeachment. You're in a position that if it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. This is not a jury. We don't have to worry about a jury hearing something that it will no longer consider. All we're doing now, with all due respect, and I understand there's a process. The state doesn't want something to be heard.
I object to that.
They've repeatedly attempted to stop questioning. Your Honor can hear it all and then decide what is and is not relevant or admissible. We don't have to go through every single one of these. The only time you have to go through this is if it is in fact a communication and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this could come to the court, and the court can then decide how it wants to treat it. That's
All right. I appreciate that, Mr. Sadam. I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible.
Court permission, I'd like to make it clear that the sexual assault I'm referring to was the same employee that I asked Mr. Bradley about. I just wanted that to be clear.
Okay. Relevance. We can make those part of the record, and I'll reserve whether this reopens a full hearing format, but the exhibits themselves, I'm willing to have.
Past the bar, and we hired him and another individual. The other person didn't stay long. Yes, but we didn't have that the entire time.
There was
Yes.
a period of time that we've been talking, or that we had talked about in 2022, prior to leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all bought a building together.
Yes, correct.
And it made things simpler, or for whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts there, they're not with the joint entity, correct?
No, they're not.
Those are all with you individually, is that right? You take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
23, what's the hourly rate that you're being compensated? That was it.
23 is the I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
150 an hour.
150 an hour? All right. So the 150 an hour, the way I understand you all shared profits was you get 50, Mr. Campbell get 50, Mr. Wade get 50, and then y'all pay expenses jointly as well, correct?
Correct.
All right. What about exhibit number 24?
The privilege should still apply.
All right. Thank you all. So I think here is what we need to do as I understand the law. As I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship or in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point. And so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant.
It's the existence of it. Essentially, if he has to keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got.
No, it has to, the legal communications have to have done in furtherance of a crime or fraud. How has that been established? And what crime or fraud are we talking about?
We're talking about perjury, lying to the court.
In the affidavit filed last month.
Yes.
And so what have you done to link the communications that he made maybe, I don't know, years ago to the affidavit filed last month?
The communications even years ago. It's proof of the affidavit being incorrect, being false. He's given a prior inconsistent
but
statement.
the legal communication has to be in furtherance of a crime or fraud.
Right. Right, but he also can't protect. So, and I think it's more under.
But if he had no idea, an affidavit wasn't even going to need to be filed until a month ago.
Right.
And these communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
It's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that. When he waives the privilege, and he waived the privilege, he testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what the law in this area is. And beyond the real kind of throwing out fraud and this and crimes, which what you have, Your Honor, is a conflict of
So I agree with you there that you would have to first establish a crime or fraud claim obligations. Got it. And anything else?
just that we can't, under the guise of impeachment of this witness, we want to establish that. And two, the witness already said he didn't have any personal knowledge of that. And there is no, the kind of specificity that is required to lay the predicate for a crime fraud exception to attorney-client privilege. No work goes to that.
Okay. Anyone else want to be heard? Mr. Seda.
This is what I said earlier. This is not crime fraud. The scenario in the case I submitted.
Go for it.
Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. It is 60 Northeast 2nd, 8 out of the Court of Common Pleas. References. I think it's page 256. The point in the case, or the point in the case, if the party or witness chooses to testify falsely, and our position is the way to testify falsely, and the relationship did not begin until 2022, that if there are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that, here that the relationship, the personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which will be the day that we decide, that if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date and the attorney-client privilege under those circumstances, where that material fact is pierced, and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, yes, and the court may have to give some of this ex parte in camera to determine, but if this witness is able to testify that Mr. Wade told him, under whatever the circumstances may be, that the relationship with Fonnie Willis began before November 1st, 2021, we know from the witness testified to Wade that he lied under oath. That's a fraud on the court, and the attorney-client communication that specific matter is pierced and needs to go into record. Now, how best to do that? The only way to do that, if it's not in writing, and apparently it's not, is for the court to hear in camera, ex parte, what the communications were that are sought to be kept in. If the court deems that the contrary to what's specified, you would accuse it. If, on the other hand, this witness honestly, that is now talking about Mr. Bradley, actually testified to what he had told in text messages to Ms. Merchant on behalf of Mr. Roman, and he absolutely knows that the relationship started before November 1st, 2021, then he's testifying that his client took the stand and lied under oath or did a fraud upon the court. So my request in this regard is what's going to have to hear from counsel and from counsel to Mr. Bradley and from Mr. Bradley to determine whether or not he actually said what he said to Ms. Merchant and whether or not it was based on communications, whatever it took place with Mr. Merchant.
All right, Mr. Seda, I understand. Thank you for clarifying your argument there. So I understand this fraud upon the cart theory. And what I've been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime. And to me, that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely, potentially unconnected to the communication whatsoever. Is that fair?
Falsity was occurring now.
Right.
He was simply using communication as a shield to
Sure.
protect his law.
Okay.
That's, and when I say crime fraud, it's a fraud waiver is what, that's what Millich calls it is essentially. I mean, Millich says that it doesn't offend the privilege to ask an attorney to testify to matters already freely discussed by the attorney and a client at another hearing or proceeding. Allowing a client to selectively waive and reassert the privilege as tactics dictates, suggests that the client is using the privilege as a sword and not merely a shield.
So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question is going to be, has it ever been applied in Georgia?
And the answer to that is, it's not a physical thing applied to Georgia. I cannot find a case in which it's been applied. The cases that I have cited in there are the only thing I've been able to work with. Although I think that the bar rules, if we want to go back to it, and I have in front of me, that the lawyer should not allow clients to commit fraud upon the court. And I think that the bar rule gives the court the discretion to do that. And the only way to make the record, even if the court even if the court disagrees, there's no way for there to be a record about it unless Your Honor does it as part of the determination of privilege. Which, of course, Your Honor knows how judges can do it. They can do it with any privilege. I'm asking the question, when I get up, I'm going to ask you that. I'm not going to go through this. To find out whether or not Mr. Wade has ever told Mr. Bradley in his capacity as his attorney or otherwise that the relationship started earlier than what Mr. Wade did.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again, we're hearing the words a matter of first impression here. And noted. Mr. Gillen.
Yeah, very quickly. Number one, apparently that now he's claiming which he certainly did not assert when he was communicating the text.
Sure, but do we have any indication Mr. Wade didn't allow him to communicate by that text?
We know what he did. We know what he did.
So how's that an implied waiver?
And I would assume that as the attorney, that he would know whether or not he should be protected a communication.
That's a pretty big assumption, right?
Not all communications are protected. Number one. Number two, let's not forget how we started on this journey with the state getting up and making very serious allegations against this person, asking for sanctions, saying all of her representations were inaccurate. And now they are doing whatever they can to block access to that information, which shows exactly what she said was exactly the truth. What they're trying to do is they're trying to say to the court, the 100% accuracy of his declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows, because what he knows is that this relationship, based upon what we see from the text and what we see in the context, would show that the relationship started before November. So I think that's a reason of a crime fraud. The issue about crime fraud is whether or not in any context the communication would be not included as a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the privilege, the law basically says this privilege which blocks evidence from coming in. So in order to have that, we have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by this one.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client? When you say you lack personal knowledge, does that include anything you may have seen or heard outside of communications with a client? And you can tell me if that question is more rephrased.
You're trying to rephrase it for me, dude? I'm sorry.
When you say you lack any personal knowledge,
Yes, sir.
that also means that it includes anything you may have seen or heard outside of communications.
Outside of communications with my client. That's correct.
And communications that were made, if any, that relate to the subject you're asked to, with any other third parties present that may have resulted in a waiver of privilege.
Including text.
Am I answering your question or her question? Okay.
Any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
No, Judge. I can't recall anybody being present. I mean, we ran an office. We had people around the office, but no, I can't say that there were other people present.
All right. And did you ever receive any kind of a waiver from the client at any point?
I have not received a waiver.
And anything that you learned regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
That's a broad question, Judge, to answer, because the advice was given, and then you have interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, or, you know, I can't sit here and say that. So I don't know how to answer that question, Judge.
All right. So
in the case, okay? The protection extends only to communications after the act of transaction is finished. It does not cover communications in proposed effect of the law and the the privilege communication may be a tool of defense if the crime is already committed, but it cannot be used as a form or weapon of defense to enable persons to carry out complicated crimes against society's laws or approaches. So, opposition, as I indicated before, the witness, Mr. Wade, has committed perjury on the witness stand. He called into question the statement.
all right, understood, Mr. McDougal.
Your Honor, this is adjacent Georgia law, perhaps not controlled, has to do with professional conduct. 3.2 A2, lawyers shall not knowingly fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting criminal or fraudulent acts of performance. page 4 of the legal knowledge because we're talking about going to court. I believe this rule is regarding the conduct of applicants representing clients. It might not govern or control the situation basically.
All right, fair point. Okay, Ms. Tripp, anything you want to address on that?
Clearly, there's a lot of smarts in this room, but this whole thing is a deductive fallacy. It is suggested that the truth of the conclusion of the argument necessarily follows from the truth of the premises given, and in fact, the conclusion does not necessarily follow the premises given. From the perjurer, he has officially succeeded in saying the thing itself is true, therefore, we must ask these other questions. And judge, it's fallacy. It does not exist as such, and the privilege should still apply.
Thank you all. So I think here is what we need to do, as I understand the law. As I find that the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship or in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point. And so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of privilege of the premise. He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So we talked about Ms. Willis and Mr. Wade coming to and from your office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Okay.
Just asking if you
Oh,
recall.
do I recall? I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I'm gonna check to that.
Does he recall
Actually, I
Ms.
think I
Willis
got- I
taking?
got it.
You can answer the question, sir.
I do recall security detail bringing Ms. Willis to my office.
Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had security detail before she became DA. So I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think. But I do remember twice her coming to our office, correct?
And she had a security team both of those times.
There was yes, she has a security team with her.
And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well, let me ask-
However,
I'm sorry.
I don't know her security team now. I don't know her security team now.
You remember telling me that it changed at some point, her security team.
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that, no, but
Do you recall talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah, Objection based on, we don't know the source. This is either based on privileged information or it's hearsay. Either one.
It's neither. I asked if you recall.
You need to clarify it. If you're actually going to think, if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. So sustained.
Are you aware of other people that you believe would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So if maybe you can ask more overarching questions, and if you have anything else you think that's relevant, then you can get to those as well.
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
You emailed me, and
Okay. All right. So there are things contained within that, Ms. Merchant, which he has now said fell within the privilege, and they did not have the ability to waive. So I think that's where we have to leave it there.
And I believe I still have to ask the questions, and then if he wants to sort of privilege.
Well, I think he's pretty much already established the privilege, and the objection has been made, and I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see. And you had knowledge about an apartment. I'm not asking what Mr. Wade told you in furtherance of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone, and Ms. Willis was staying there.
Judge privilege.
I think in the way the question's phrased, she qualified that. So
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge at all. No,
So no knowledge outside of what is privileged.
that's correct.
Did you have texts between yourself, Ms. Willis, and Mr. Wade?
Do I?
Have you ever?
I have. Maybe once or twice, but
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection
on
on privilege. We still the same thing.
just asking to use your credit card, how's that in the nature of furthering a divorce proceeding?
We were talking.
I had a business card, and we would use my business card. The firm would use my business card.
For travel?
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
I recall I recall a trip, but I don't know if that trip has anything to do with this case. So I do recall him using my card once.
When was that?
I don't even know when that was, and that's not the truth. I recall him using my card once, but I cannot remember what that was for. I do remember it was a trip, but I cannot accurately state, where it was and who it was with or anything like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or a check. We routinely would use my card for filings, for paper, for whatever stuff with the office. And so,
oh, I'm sorry. We're done, sorry.
and so he would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel.
I cannot recall. I don't even have that business card anymore. But I do recall at least once for travel. Yes,
And that was when you were still law partners with him, correct?
that is correct.
Do you recall approximately when that was?
I do not.
You did not go on that travel with him, though, correct?
I did not.
Okay. And so he asked you to use your card for the travel.
Yes, I mean, I'm assuming. I mean, we would use the card for firm stuff, and so it was a business card.
Your business card,
It was my business card. Yes,
Right.
the law office of Terrence A. Bradley. Correct.
Okay, so it showed up on your accounts.
That is correct.
Okay, wouldn't show up on his accounts, is that correct?
That would be accurate. Yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Ms. Willis together? You said you were in and out of the office, in and out of the DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
You saw them together in and out of the DA's office.
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the taint team.
Okay.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
So, brought up the taint team. Let's talk about that for a minute. Tell me about you did work as you had a contract as a taint lawyer, correct?
That is correct.
And that was in the anti-corruption unit.
Yes, I think so. Yes, correct.
And how did you get that contract?
What do you mean? How did I get it?
How did you get the contract?
It was.
Did you bid? Did you apply online?
Oh no. It was proposed.
By who?
We were. It was proposed by. I guess it came from the district attorney. I mean, I didn't speak directly with her.
Okay.
It was with Mr. Wade, and he asked if we would be interested in having a contract with the Fulton County.
Okay. He
I
asked
said
you,
I would.
Mr. Campbell.
I think so. I mean, I can't recall if he asked us both together or not. Rarely. We all handled several, different things for the firm,
Okay.
criminal, personal injury, things like that, family law. And so rarely were we together there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't recall how we got the contract, but
Did was Mr. Wade, to your knowledge, part of the transition team for Ms. Willis?
to my knowledge, he was part of the transition team.
Did he spend a lot of time at that office during this transition period?
He did.
So from when Ms. Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
When you say most of his time, you're saying just working business hours, or
Working business hours.
I would say he spent. I would probably say he spent majority of time. If you say over 51%, I would say yes, he spent over 51% of his time.
And that was the entire time from when she took office to when you left the firm.
I can't say that that was the entire time, but yes, it was majority of. It was a. I mean, I can't pinpoint specifically when the time that he would spend. I think if my memory serves correctly, getting to the majority of the time, it would have been whenever he started with this, maybe. That was
As a special prosecutor?
when you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. I mean, it depends on what you say is a lot. He spent time at the DA's office, correct?
And so just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners, and you were both hired by the DA January 25th, 2021. Is that correct?
Repeat the question, I'm sorry.
You and Mr. Campbell
Yes.
both were hired
Mhm.
on a contract basis by DA Willis,
Mhm.
January 25th, 2021, correct?
Which contract are you talking
The
about?
first one, the taint contract, not the first appearance contract, the taint
Okay.
contract.
Well, you said the first one, and the tank contract wasn't the first contract. And so,
Okay, so what was the first contract?
to my knowledge, the first contract was the first appearance.
Okay, so let me just mark these and see what number it is. 23, 24, 25. What is that? Judge, when they're done reviewing the contracts. Ms. Riley, showing notes did March, like I said, at 23, 24, and 25. You just put those.
Okay, that's it.
So on, now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a tank lawyer, yes, I see the date on that as a tank lawyer, but I'm also looking at this contract here for first appearance, and there must have been. I don't have it before me, but there must have been a contract before this.
Okay, so you think there's a fourth contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID, and it was before 2021. So I don't know. If I had a written contract at that particular time or anything, but I do know, I think that you could look at the recordings because everything was recorded at that time as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least two contracts to do taint work, which is filter work, and then at least two contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So, it just renewed. So yes, if it was the same contract, but it was a renewal of
Okay.
the contract.
So how did you, and you said you got these contracts through, Ms. Willis gave them